Good day, Crime Talk aficionados. We have a great show for you today. First, I think I may have been wrong about the prosecution in the Bryan Kohberger matter. A jury has been seated in the Lori Vallow conspiracy to commit murder trial in Arizona. Karen Reed trial has begun with jury selection, but no jury yet. New York City Mayor Eric Adams' case is dismissed after the judge says it was okay. Like he has any say in that matter. Another ruling against Jennifer Crumbley. And keeping in that line, several teens were misbehaving in Tennessee. Why were the kids' parents not charged? And we have another update on that school teacher who really likes her students. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, you may say, Scott, what are you doing casual yet again? I thought you were supposed to be in trial again. Well, yes. And now both matters are over, so I can tell you a little bit more about it. So last week had a trial, big drug case. All right. Supposedly major kingpin in this community. They had wiretaps. Only problem was they didn't have any drugs. It was what they refer to as a dry conspiracy, dry wiretap. Anyway, needless to say, after a week of trial, the jury made the correct decision and found my client not guilty. And frankly, I think it was one of the better closing arguments I've had in a long time, not going to lie. Anyway, the client had two charges, the underlying case and then another case when he got arrested, they found some controlled substance in the car. Frankly, I'll be honest with you, I thought the second case, the one that was going to start, yesterday, well, I thought that was the easier case to beat, to be honest with you. Anyway, an offer was made that the client could not refuse, and I got to come home early. Got home about 10:30 last night, but at least I kind of have the rest of the week to, get caught up on other things that I need to do. So sorry I missed putting out shows last week, but I was a little focused in trial, and hopefully you understand when I'm in trial, I focus on that case because it is so important to not have any distractions when you're in trial. It's kind of like flying an airplane. You can't be distracted when you're flying an airplane. It's kind of like trial. The whole world shuts off. Nobody knows, if they're going to hear from you. So anyway, welcome to the club, so to speak. All right, let's get rolling. But before we get to the docket, go to crimetalksearch.com. All right, sign up for that background subscription service today, because when you do, you're going to be able to do as many background searches as your heart desires on anyone, ladies and gentlemen. I don't know, people in high publicity trials that are listed as witnesses. Maybe you want to check them out. See if there's something maybe somebody has missed. Either way, if it's high profile or somebody in your life, somebody coming into your life, you get that report. It's emailed to you. You get updates if you so choose. And that report is going to have information about property they own, vehicles, right? Email addresses, phone numbers, involvement on the internet as it relates to social media presence, criminal history. Do they have judgments against them, liens, anything along those lines, ladies and gentlemen, you're going to find out. Information is power. Go to crimetalksearch.com, embrace that power, check people out that are coming into your life, or decide maybe somebody needs to get out of your life, okay? It literally could save your life if you let the wrong person in and you don't get rid of them. So go check them out, crimetalksearch.com. All right, let's go ahead and open the docket for April 2nd, 2025. And first on the docket, Bryan Kohberger. I may have been wrong about the prosecution in the Bryan Kohberger matter. Now, they looked a little disheveled early on in the Bryan Kohberger matter. They seemed to be, seemed like a little behind the power curve because Bryan Kohberger's attorneys would show up to the hearings and kind of slap them around a little bit. The prosecution looked like they were a little out of their league. But as I was going through more and more of these documents, we got a stack of filings that the prosecution and the defense have been going through. But I think it was interesting. This state's reply to the defendant's objections to the motion in limine regarding self-authentication of records. Now, I'm not a big fan of self-authenticating records myself, but maybe because I am a defense attorney by heart, okay? It basically makes it easier for the government to not have to bring in a witness. And, who knows, maybe the witness gets, hit by a big bus. They get stranded at the airport. You never know. All right. So they basically created a rule that says, hey, if you can lay the appropriate foundation for these business records, saying that they're conducted in the normal course of business, you can send a little certification like they did here for the Amazon, saying that they're an employee, they're familiar with the documents, all the documents that are produced are authentic, and they are what they purport to be and accurately describe the transactions, communications, and events set forth therein. The problem for the defense is the documents come in and there's nothing that you can really corroborate them about. But once they're into evidence, then the prosecution brings a detective up to the stand and say, are you the lead detective in this case? Yes, I do. Are you an analyst? Yes, I am. Whatever. And they say, well, why don't we take a look at this? Let's kind of walk through the timeline, right? We talked about the timeline. It's all of these video surveillance cameras that were around the property where the quadruple homicide took place. And they literally track Bryan Kohberger's movement that night, track some of the victims, the Dick's Sporting Goods purchases, the Amazon purchases. It's all there. Now you may be saying, okay, Scott, I get it, but he's still entitled to the presumption of innocence, and he is. And it's going to ultimately be up to the prosecution to prove the case beyond a reasonable doubt to each and every element of the offense charged that it was, in fact, Bryan Kohberger on or about the date and place charged, not somebody looked like him, not someone using his identity, but it was, in fact, Bryan Kohberger that unlawfully, which means without legal permission or justification, took the lives of those 4 young people on November 13th, 2023. That's what they have to prove beyond a reasonable doubt. And if the prosecution fails to prove just one of those elements, it would be the solemn oath and obligation of those jurors to say not guilty. On the flip side, if the prosecution proves each and every element of the offense to the satisfaction of the jury beyond a reasonable doubt, it is their solemn oath and obligation to find him guilty. The jurors are judges of fact. The judge decides legal issues. The jury simply decides, did what was alleged take place? They need to make their decision with neither passion nor prejudice and simply say, this is what we believe took place. Was it, in fact, Bryan Kohberger on this date and place charged unlawfully took the lives of those 4 people as well as committed a burglary? And if that's the case, like I said, they'll make their decision either way. Now you may say, okay, Scott, well, what's the big deal? What were you wrong about? Like I said, I thought prosecution seemed a little slow out of the gate. Maybe, thinking, a little small town jurisdiction, not used to this publicity, the amount of discovery. They just seemed like they were back on their heels a little bit. And I have done this throughout the years. If I am wrong, I will say that I am wrong. Because, I'm not one of those people going, hey, we all make mistakes. And I think that I may have been wrong. And let me tell you where I was. Early on, I said, hey, Bryan Kohberger's attorneys should have had the proverbial come to Jesus meeting with their client and say, hey, listen, here's the deal. You got a speedy trial right. 6 months from the date that you say not guilty, by God, we're going to get you a trial and let the chips fall where they may. And if you did it, we should probably know, and we're just going to move forward and see if they can prove their case beyond a reasonable doubt. In the alternative, they can say, or we can wait and see see if the prosecution can get their ducks in a row. Blush, and what I've said before, I have won many a trial, particularly homicide trials, where literally the prosecution thinks that you will always ask for a continuance on the first trial setting. And when they don't, they're the ones that are on their heels. So I said, hey, I don't know if Bryan Kohberger did it. I still don't know for sure. Obviously, there's evidence that points his direction. We'll let the jury decide whether it is sufficient to prove that. But the point here is, if he was going to, I said, if he had a shot of winning that trial, he should have gone on that first trial setting. And I don't know if his attorneys talked him into it or they're like, hey, and I get it. When you get a big case, you're like, man, there's 50,000 pages here. There's hundreds of thousands of pages, plus all the video and everything. There's no possible way that you could possibly go through it all. Well, probably neither can the prosecution, right? So you're both kind of on that uneasy platform. And if the client had demanded you go to trial, just like in the Lori Vallow case, she demanded to go to trial, wasn't going to waive speedy trial. It actually worked to her benefit, right? They got the death penalty dismissed because the prosecution hadn't timely turned over evidence in that case. So from the time that the prosecution got this case, the murders took place in November of 2022. All right. So that means the prosecution has had all of 2023, all of 2024, and going to have 8 months of 2025. So they've had 2 years, 8 months, plus, part of December, right? So 2 years, 9 months to get all of their ducks in a row. Anyway, so I think that I may have been wrong, right? Because obviously the murders were November 13th, 2022. As I was going through the state's reply to the defendant's objection to the motion for limine, I started looking at some of the dates on these records. The Amazon self-authenticating documents affidavit was executed on December 30th of 2022. They would have had that in plenty of time for Mr. Kohberger to get to trial. The other Amazon certificate of authenticity executed June 27th of 2023. Would have had it before that other trial. AT&T self-authenticating records 12/23/2022. AT&T March 24th. This was a more recent one. They updated it as it relates to the time search. March 24th, 2025. So the point that I'm trying to make here is that so many of these documents were done way back in late December of 2022. More AT&T records, updated certificates. They were ready, ladies and gentlemen. They had so much of this information. And now Bryan Kohberger spent the last 2 years saying, oh, we need to look at all this. We need to look at that. And I get it. I've been in those type of cases where you're like, man, we got to look for something, right? There's got to be something out there we can work with. And it turns out, I'm a defense guy. I'll always kind of root for the defense, but as I've always said, you can't drink the Kool-Aid and think, oh my God, this is always just a great case. You have to be able to explain away the bad facts, or you got to be able to make the bad facts go away. And the defense in the Kohberger case has tried to make the bad facts go away. First, right? They tried to make the investigative genetic genealogy go away, to take away the DNA. Didn't happen. Then they want to keep out all of these records of all these transactions between Dick's, where they're buying the mask, the knife, where they're buying that at Amazon, right? They're trying to keep everything out that the defense is realizing is bad as well. Now, would the defense have been able to engage in the motions practice that they did if they had gone in the first trial setting? Absolutely not. And so the attorneys were probably worried about me, whether they're going to be effective assistance of counsel, right? Nobody wants to be found ineffective. Unless, of course, you have your client sign away a big waiver saying, understand the risks, but we're moving forward. So, yeah. And I don't think it's going to turn out well for Bryan Kohberger, because the state has got so much time to get their ducks in a row. Like I said, so much of this, they already had it done way back there in late 2022, 2023. They've had 2 years to prepare, going almost 3 years. I mean, the receipts, the DoorDash thing, all the video surveillance. I mean, it's all coming in. And like we talked about yesterday, the crime scene scenario final, they brought that in, all right? Or they're going to try to get it into evidence. And if you look at the crime scene scenario final that we talked about yesterday show, and what that shows is, okay, yeah, it's an exam. I get it. Is it relevant? Well, it is if, the defense says, oh, we're not familiar with anything as it relates to how to commit the perfect crime, so to speak. We're not familiar with those big city ways. But it's going to be offered to show that he has knowledge of how an investigation is done and steps that were taken to thwart the transfer of evidence at the particular scene. There's a couple of interesting things. Yeah, I get it's an exam, but the way he methodically walks through and says, I'd want to do this to avoid any sort of transfer whatsoever of hair, skin, DNA. I think it'll ultimately come in. Like I said, the DoorDash records that they have going to 1122 King Road, they had this all ready to go back in November of 2022. So hats off to the prosecutors, hats off to the investigators in this particular case. As a defense attorney, I will say it looks like you had your ducks in a row, and it looks like you're going to have your ducks in a row even more so now when we get to trial in August. So if I make a mistake and I say I'm wrong, I'm wrong. Like I said, we'll still give the defendant, Mr. Kohberger, the presumption of innocence, but the reality of it is it looks like everything is coming together for the prosecution. And I'm a defense guy. I'm just looking at everything laying out. They're going to piece all this together, and it's going to be a long trial for the defendant, ladies and gentlemen. It's going to be a long trial. And as we talked about yesterday, maybe they're going to call him as an expert witness to talk about crime scene contamination. He thinks he's smarter than everybody else. We'll have to wait and see. Next, let's talk about Lori Vallow. That's right. A jury has been seated in the case against Lori Vallow, who is charged with conspiracy to commit murder in the first degree in the death of her fourth husband, Charles Vallow. Well, we're going to have to wait, though, until April 7th, next Monday, for opening statements. Now, as we've talked about, Lori is serving a life sentence in Idaho because back in 2023, she was convicted of murdering her two youngest children, J.J. Vallow and Tylee Ryan, and conspiring to kill her fifth husband's first wife, Tammy Daybell. Chad Daybell was also convicted for the same charges, but he was a little less fortunate. He got sentenced to death. Now in Arizona, Lori Vallow is acting as her own attorney. Why not? She's had plenty of experience going to trials. I'm sure she'll completely master the rules of evidence between now and Monday, and we'll see where things go. Now, remember, the prosecution has to prove a conspiracy, an agreement between two or more people to commit an illegal act. Her brother, Alex Cox, is dead. So they're going to have to try and use these statements, assuming they can authenticate them, and have an exception to the hearsay rule to show that there was an agreement to kill Charles Vallow between the two of them. Now, obviously, the crux of it's going to be that Alex is at the house, Charles shows up, they're going to talk, there's some threats. Coincidentally, Lori Vallow just happens to leave to pick up JJ, and all this goes down. And you saw the videos where she's standing outside. Oh my gosh, my husband's killed. Oh my God, that's terrible. Oh, can I get a couple of items out of the house? You know, that's where it is. We're going to have to wait and see how it goes. It's going to be interesting. We're going to bring it to you live. So, come check it out here at Crime Talk. Now, she is also accused of conspiring in an attempt to kill her niece's ex-husband, Brandon Boudreaux. That trial will go after the Charles Vallow trial. She'll probably want a little break in between because she's going to find out trial is exhausting. It's not just sitting there, looking pretty, which, apparently that was her MO in jury selection, kind of flirting with the men in the room. Have to wait and see. Now, just a little background. Lori Vallow was married back in February of 2006 in Las Vegas to Charles Vallow. And then in 2013, the couple adopted JJ and Charles' sister and her husband, Kay and Larry Woodcock, who were JJ's grandparents. In 2016, the couple moved to Arizona, where they settled down with Tylee and JJ. 3 years later, Charles filed for divorce, indicating he was concerned about Lori's mental health. Anyway, Lori's older brother, Alex Cox, fatally shot Charles Vallow on July 11th, 2019, while he was arguing with Lori after picking up JJ from school. Police said during the argument, Alex claimed that Charles hit him over the head with a bat. Alex told police that after he had been hit in the head, he went and retrieved a gun from his bedroom and then shot Charles in self-defense. In the probable cause affidavit from the Chandler Police Department, investigators say no emergency aid was provided to Charles, and he was left bleeding on the floor for about 43 minutes before that 911 call was made. It's going to be interesting. Is Lori going to be held holding the bag, or is she just an innocent victim, a helpless little flower that just happened to be caught up in this testosterone-driven argument between these two men, her husband and her brother. We'll have to wait and see. Next, the Karen Read trial has started, and they are seating a jury there as well. 76 potential jurors said they had heard of the Read case, and another 38 said that they had actually formed an opinion about the case. So nearly half of the first group of potential jurors told the judge they had already formed that opinion. So 76 jury members raised their hands to actually acknowledge that they had heard of the case. 40 had already formed opinions. 16 said they had already had bias or prejudice for or against either the defense or the prosecution. So you can say, adios, we're out of here. So as of today, Wednesday, 2 jurors were seated and 2 other jurors were seated on Tuesday. The court is looking to get 16 jurors. 12 will be the deliberating jurors, and then 4 alternates just in case, because the trial is supposed to go several weeks. Now, the judge also gave a ruling yesterday, and the judge said the prosecution would be able to call Judson Welcher, a biomechanical engineer and accident reconstructionist, as a witness. The court noted Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert, the judge puts in an order. And his report demonstrates that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented to the jury for their consideration. And things got a little weirder. Now Karen Read has 5 lawyers in the courtroom with her. Nothing makes you look more guilty than having 5 attorneys. Just saying, you got to be conscious of those things. And one of the jurors is Victoria George, who was an alternate juror in the first case. Now, I don't believe Ms. George has any experience doing criminal defense, so I think it's all a big publicity stunt. And the reality of it is, it doesn't matter what she thought as a juror. Don't try your last case, right? It's like military. Don't fight the last war. You got to let it go. Okay, let me give you a quick example. All right. Years ago, young lawyer, I was asked to do a second chair on a homicide trial. I didn't do the first trial, but I read the transcripts. I got to do the retrial. And the lead attorney was like, hey, listen, man, the first trial, the jury got really wrapped around something here. The jacket was coming off, and we got to focus on that the second time. That's what hung it. Oh, okay. I mean, I wasn't there, but okay, I get it. I kind of see. Anyway, needless to say, we went to trial, client gets convicted, talk to the jurors and say, hey, you found her guilty. Why? And then they told us, like, she hiked through the snow, through the woods to get to, ex-husband's house with new girlfriend and, shoot everybody. Kind of a bad fact, right? And they knew who she was, and et cetera. I said, well, we asked about, what about the struggle with the jacket? And the jurors looked there and said, yeah, we just didn't see where you were going with that. Didn't really make sense to us. So the moral of that story is each jury is separate and distinct, okay? And you need just one juror, take everybody down a path saying, hey, what about this? And you never know the personalities of that particular jury. So the moral of that story that I learned was, don't try the last case, particularly in a retrial. And the prosecution knew exactly what the defense was going to do the second time around. That's why I keep saying, ladies and gentlemen, it doesn't get better for the defense the second time around. The chances of Karen Read being convicted have gone up exponentially this time around. Throw it out there. She's entitled to the presumption of innocence. I would have found her not guilty of the first trial based upon the terrible performance of the prosecutors in their first trial. We'll see about this time. I think they got a much more experienced prosecutor who has literally, in my opinion, dismantled the defense case the second time around. Hence the reason my theory, it never gets better the second time around. So defense, don't go try your last case. You got to mix it up. You got to give them something that even the prosecution wasn't expecting. If you go with the same old trial again, guess what? She's going to be convicted. Anyway, for those who don't know, Ms. Read has pled not guilty to second-degree murder and other charges. And the prosecution says that she hit her boyfriend, John O'Keefe, with her vehicle outside of a home in Canton, Massachusetts during a snowstorm back in January of 2022 following a night of drinking. Her defense team has argued, however, that someone else is responsible for the death of her boyfriend and that Ms. Read is the victim of a great conspiracy and cover-up. Next, Eric Adams, that's right, the mayor, his corruption charges have been dismissed. So New York City Mayor Eric Adams, historic federal corruption case has been thrown out, leaving him free to campaign for his second term without the threat of prison hanging over his head. Now, the Judge Dale Ho, ordered the case to be dismissed on Wednesday with prejudice, which means that they can't refile, formally killing the criminal case that has hung over the mayor's head for the past 6 months. The court said, to be clear, the court again emphasizes that this does not express any opinion as to the merits of the case or whether the prosecution of Mayor Adams should move forward, he wrote in his 78-page opinion. The court notes only that it has no authority to require that it continue. Duh. Ultimately, because the decision to discontinue a prosecution belongs primarily to a political branch of government, it is the public's judgment and not this court's that truly matters. Duh. The hotly anticipated decision by the Manhattan judge followed a political firestorm ignited by President Trump's Department of Justice ordering the prosecution to be dropped against Mayor Adams. The move led several attorneys generals to resign. The controversial decision led the Deputy District Attorney General Emil Bove last month sparked accusations that the Democrat mayor engaged in a quid pro quo with the administration in exchange for cooperation with Trump's crackdown on illegal immigration. The governor even opined that the door to potentially removing the mayor from office is a possibility, but ultimately decided not to do that. Now, as you may recall, Mayor Adams was charged in a 5-count indictment, including bribery and fraud. And then in September, he had pled not guilty. He was accused of pocketing more than $100,000 in illegal campaign contributions and receiving travel perks like upgrades to buy influence from including a Turkish official. But Bove, the attorney general, claimed that the case was a politically motivated prosecution brought by the then Manhattan U.S. Attorney Damian Williams, an appointee of President Joe Biden. He also argued that the mayor could not properly do his job, putting New Yorkers at risk, as the ongoing case left him without a security clearance to get briefed on major threats. But he didn't address the merits of the case in his motion and also urged that the door be left open to revive the prosecution following the November election. Now, the DOJ letter ordering federal prosecutors to drop the case sparked some exodus from the Department of Justice and the Southern District of New York, which brought the case, including the head of the office, Daniel Sassoon, who raised the quid pro quo allegations in a searing resignation letter. Judge Ho appointed lawyer Paul Clement, who served as the U.S. Solicitor General under President Bush, to help advise him as to the options that he could do. Anyway, Clement advised the federal judge he had a few avenues to go down, saying he had no power to name a special prosecutor, and any attempt to keep such an appointment alive would be futile. And then the attorney wrote that, however, the judge could change the dismissal type with prejudice, killing the case forever, and argued that that would align more with the DOJ's argument to remove the all political taint. Even the appearance that the prospect of reindictment would cause public officials to be more attendant to the executive branch than to constituents in deeply troubling and raises serious accountability concerns, he wrote. So anyway, this judge just got schooled in that it's not his decision. Defendants always say, I want my motion to dismiss filed for lack of evidence. You say the judge has no authority to dismiss the case unless he made some findings that there was some sort of prosecutorial misconduct. And that's just not going to happen. Or maybe there wasn't evidence to sustain probable cause at the appropriate preliminary hearing. But when the prosecutor comes in and says, I'm going to dismiss this case, even if the prosecutor doesn't agree with it because his boss told him to do it, the judge has no say in it. It's not his decision, right? The judge is there. They don't get involved in plea negotiation. They don't get involved in the prosecution. They're supposed to sit there and call balls and strikes and rule on matters of law. Okay. But this judge somehow thought he had the right to make the opinion as to what case should go forward. I've told this joke before, and it's a joke, and it's true. Okay. Somebody told this to me a long time ago. Still funny every time. Makes me chuckle. Do you know what the difference is between God and a United States District Court judge? That's right. God doesn't think he's a United States District Court judge. Okay? They think they're the most powerful people in the world. And when you go in there, you got to kind of genuflect and be nice and polite because they are a judge. and they are appointed for life, but they're a court of limited jurisdiction. They don't get to make decisions of policy from the executive branch. Anyway, finally, that case resolved. And don't get me wrong, I'm no fan of politicians of any political party. And if there is corruption, they should be absolutely prosecuted to the fullest extent of the law. And frankly, I'm of the opinion that politicians shouldn't get any perks whatsoever. That includes upgrades, free rooms. The biggest scam of all is that they cannot accept more than usually like $25 more in gifts, but they have all these exceptions, right? For fact finding, for education, right? And they always take these politicians on an educational fact finding trip to, Normandy, France, all these great locations and stay in 5-star hotels that are, of course, paid for by corporations and lobbyists. Get the money out of politics, ladies and gentlemen. You get the people there that are going to serve for public service. You shouldn't get rich in public office, right? You should work for $1 a year. And frankly, if you can't do that job for the very short amount of time, 2 years, 4 years, or 6 years if you're a senator, then maybe, you are not sufficiently successful enough to be there. But if you get rich while you're in public office, that should be per se corruption, and people should be prosecuted. Think about it. You make $200,000 a year, but yet in a matter of years, you become worth $26-30 million. Please tell me how that happens. That's where the corruption is, ladies and gentlemen. Next, let's talk about Jennifer Crumbley. An Oakland County judge has ruled that her court does not have jurisdiction to decide a motion brought by the attorneys for Jennifer Crumbley to disqualify the prosecutor's office from the case. Now, Crumbley was convicted on 4 counts of involuntary manslaughter connected to the deadly Oxford High School shooting back in November of 2021. Her son was the shooter who killed 4 students. And her husband, James Crumbley, was convicted on the same charge. In addition, the Judge Cheryl Matthews, found that the motion itself was brought for an improper purpose and ordered that Crumbley's attorneys be sanctioned for bringing it. Now, the attorney, Michael Desi, filed the motion in the court stating that McDonald cannot be trusted to prosecute the case, that's the prosecutor, consistent with the constitutional, legal, and ethical duties imposed upon her office. Now, the judge ordered that the attorney, Desi, will not be reimbursed the cost of filing the motion since she did not even have jurisdiction to decide it because Crumbley has filed an appeal of her conviction, which makes complete sense. Once the trial court level is done and you file the notice of appeal, the district court loses jurisdiction. You have to ask for a limited remand to hear any motions as it relates to anything that you think should be done at the trial court level. But you have to get permission from the appellate courts to do that. And to just file this saying disqualify the prosecution's office seems kind of frivolous to me. Anyway, but once again, at least the judge is saying, I can't do anything. I can't even impose a sanction against the attorney for filing a frivolous motion because I don't have any jurisdiction. I can't rule on it even if I wanted to. Anyway, next, keeping in line with the Crumbley decision, because, if you've been following me for a while, I think the Crumbley decision is absolutely terrible. If the Crumbleys had been told, hey, today's the big day, mom and dad, we're going to go into school, do all these terrible things, kill 4 people, they would be responsible. But to say that they should be held responsible for the child for doing things that they did not know was going to take place, not reasonably foreseeable, because that's a negligence standard, not what we require in criminal courts. I got a big problem with that. I always have. So keeping in line with that, let's talk about this little house party in Tennessee, where 200 underage teens, well, they're getting a little more than just a little talking to. They're getting charged. Why? Because some of the kids were filmed swinging on a chandelier at this party that caused about $16,000 in damage. So the Nashville Police Department has arrested 4 17-year-olds, 5 16-year-olds, and 3 15-year-olds from multiple Tennessee high schools for allegedly breaking into an empty luxury home back in February. And the police are expecting more arrests and more kids are going to be facing felony vandalism and aggravated criminal trespass charges. Now, this property is located in East Nashville, and it was up for sale. It was vacant when the teens stole a key from a locked box to get inside. Neighbors eventually caught on to the commotion and called the owner, a guy by the name of Kyle Grasser, about 9:30 p.m. back in February of this year. Now, Grasser raced over and found over 100 kids fleeing from the front door. He made sure to record the kids and tracked down footage that they posted on social media. Now, he found actually the invitation for the party on Instagram. And he said there were at least 25 students identified who posted about it. One video even shows, like I said, teens swinging from a chandelier. Now, the guy was building this property. He's not a rich guy, but needless to say, when somebody breaks into your property and damages it, it sets you back. Police arrived on scene. They found a bunch of alcohol bottles and cans and signs of drug use. Now, like I said, the owner says he doesn't want to ruin any of these kids' lives for this little party. You know, let's face it, we've all been there, right? But he's like, hey, I don't have the extra $16,000 laying around for the damages in this particular case. And he wants the kids or the kids' parents to pay. Or better yet, why not charge the kids' parents? I bet they'd cough up that $16,000 really fast, wouldn't you think? See where I'm going with it, ladies and gentlemen? Well, I get it when it's a really serious case. You know, we can't have serious cases. But if it's a little house party, I mean, who's to say the parents should have known? Should have known. Why are they not following their teenage kids around better? All the technology today? My goodness. Charge them all, I say. No, I'm joking when I say that. Next, we have an update on that teacher in Illinois who really likes her students. And I mean, really likes her students, okay? Anyway, an Illinois special education teacher is seen breaking down in tears as she was taken into custody, according to this body cam footage. Now, she's been accused of sexually assaulting a 15-year-old student. Take a look at this clip. Christina Formella. We talked about her a couple of weeks ago. Well, she's seen exiting her and her husband's car there in Illinois, and you can see the police officer tells her, just grab whatever you need. She's like, what do you mean? As her husband questions, while he's in the passenger seat, is she going somewhere? Yeah, we're going to explain everything to you guys, the officer insists, before handcuffing the suspect and putting her back in the police car. She's like, excuse me, is my husband coming with me? She asks. Am I in trouble? I'm so lost right now. I feel like I'm going to throw up, she says as she's sitting there in the police car. The officer went to get her bag as she hugged her knees and cried. Look at her crying like a little girl. Anyway, authorities previously confirmed that Formella's arrest in a statement from the DuPage County website that on March 16th, 2025, the Downer Groves detectives conducted a traffic stop on Formella and took her into custody. The police state in their update that a Downers Grove woman had been arrested for having an inappropriate sexual relationship with a student, stating that she'd been charged with 2 counts of aggravated criminal and sexual abuse and 1 count of criminal sexual assault against a minor. The victim's mother discovered the alleged assault when looking through her son's text messages on a cell phone. Anyway, court records show several explicit text messages that allegedly been sent from the married special education teacher and soccer coach to the underage student. Police alleged that the texts discuss the details of the sexual encounters. There's even one that says, I love you so much, baby. Even though this morning was short, it was perfect. Formella text the 15-year-old boy. In another text, Formella wrote, I love having sex with you. Formella allegedly told police the sexual abuse started a year and a half ago. The teacher, who was released on bond, also allegedly wrote about a 15-year-old boy in the notes section on her app phone. Ms. Formella has, past tense, has taught in the high school's special service department since 2020 and coached the boys and the girls' soccer teams. Her next court appearance is April 14th. Now, we'll give her the presumption of innocence, but she could seriously go to prison for that. If she did that in our state here of Colorado, she'd be looking at a pattern of abuse, SAOC, position of trust. She'd be looking at 10 to life. We'll see what they do in her jurisdiction. Like I said, we'll give her the presumption of innocence, but really, 15-year-old boy? Come on, man. Next, This day in legal history, on April 2nd, 1865, the fall of Richmond, Virginia occurs as the Confederate forces abandoned their capital during the Civil War, leading to legal and military consequences for Confederate leaders, including Jefferson Davis, who had to flee that day as well. On April 2nd, 1970, the United States Supreme Court decides Goldberg v. Kelly, ruling that welfare benefits cannot be terminated without a prior evidentiary hearing, strengthening the due process rights under the law. That's right. As far back as 1970, if you're getting state assistance or government assistance, they can't take it away from you unless they give you a hearing. On April 2nd, 1973, the United States government drops charges against the New York Times for publishing the Pentagon Papers. That's right, First Amendment protection. On this date in 1992, mafia boss John Gotti is found guilty. 5 murders, conspiracy, racketeering, and other crimes, marking a significant victory for federal law enforcement against organized crime. On this date, on April 2nd, 1998, Maurice Papon was convicted of war crimes for his role in deporting French Jews to concentration camps during the Nazi occupation of France. Now, under Germans' occupation, Papon served as the supervisor of the Service for Jewish Questions in Bordeaux, France, from which he collaborated with Nazi SS soldiers and oversaw the deportation of 1,562 Jewish men, women, and children before they were sent to a concentration camp. And finally, our dumb criminal of the day. You ever seen that video where the dad runs over the kids' video games in the yard and the kid just has a panic attack? Well, that is what I'm reminded of when I think of this. So this 21-year-old Floridian man, that's right, when you're 21, you're supposed to be a man, he got a little angry with his dad and drove the father's car into the ocean. Yes. Please meet our dumb criminal of the day, Joshua Kuss. He had borrowed his father's car, but didn't return it back to his parents' house in Jacksonville Beach, Florida. About 2 a.m., cops received a report of an auto in the ocean. And upon arriving to the beach, officers spotted what they believed to be a gray Subaru floating in the ocean. In the water, elsewhere in the report, the car is correctly described as a 2011 Volvo XC70. Now, police were able to locate Mr. Kuss since his father had been pinging his phone to find his whereabouts. Anyway, Mr. Kuss admitted that he littered the ocean with the car, calling it stupid, big stupid move, and that he recently argued with his father and aunt. Anyway, Kuss had sent his 2 relatives a text at about 1 a.m. warning him that I am going to drive the car into the Atlantic Ocean. However, the father of Mr. Kuss didn't take that seriously. Who would be so stupid? Well, the younger Kuss, indeed. Anyway, Kuss, investigators allege, sought to use a cinder block to send the car into the ocean. When that failed, he got into the car and drove it into the water, and he reported turning on all the lights and making sure that no one was nearby because, make sure nobody gets hurt. Anyway, while driving, he apparently was grinning and wished he could point his middle finger at his father and aunt, according to the police. And Mr. Kuss reportedly told one officer, I hope they're going to listen to me now. Do you hear me now? Do you hear me now, Dad, as I drove your car into the ocean? Well, needless to say, Mr. Kuss walked to his mother's nearby house, and he was arrested. Mother's house, because apparently his family divorced. Anyway, after his father deciding to press charges, Mr. Kuss was arrested on felony criminal mischief. The older Kuss reported a loss of the vehicle valued at $6,500. Talk about some restitution there. Oh my God, should we hold the father responsible for that too? Gee, I don't know. Anyway, Kuss is being held in lieu of a bond, $2,500 bond, which he has not posted. Now, Mr. Kuss has had some rough times. Back in 2022, he pled no contest to a DUI charge and was sentenced to probation. He was 18 at that time. Of course, you're illegal to drink when you're 18. And coincidentally, he was driving the Volvo that he drove into the ocean. Anyway, the father showed up at Mr. Kuss's sentencing and says that old Joshua has a lot of work ahead of him. And I can only hope that he learns from his mistakes and turns it into a good life lesson. Well, Joshua Kuss failed. Now you're going to have a felony for running your dad's car into the ocean. You, Joshua Kuss, are our dumb criminal of the day, possibly a contender for the winner of the month and even the year at this point. You are in the lead, Mr. Kuss. All right, everybody, that's all we have for today. Thanks for watching. We'll see you next time. Hope you enjoyed the show. And remember, the Constitution matters.